Good morning, Your Honors, and may it please the Court. My name is Dana Gallup. I represent the Appellant.SR in this matter. And this is actually the second time that we are here on appeal on this case. Just by way of quick review, we filed this case in, originally in Miami-Dade County. It was then transferred and filed in Lee County. We had a motion to dismiss hearing initially on the issues of jurisdiction, personal, and subject matter. The trial court, Judge Fuller, denied the motion to dismiss. The defendant, Telesur, Appellee here today, took an appeal of that to Your Honors, to the Second District Court of Appeal. We had oral argument, and following that, this court issued an order in November 14, 2012. And in the order, the court determined that the trial court should have granted the motion to dismiss, found specifically some deficiencies in the complaint as it pertained to the jurisdictional issues, noting in certain areas as to specifically the defamation claim and the tortious interference claim and even the breach of contract claim, that the allegations did not sufficiently discuss or allege acts that occurred in the state of Florida. As to the breach of contract claim, the specific issue was the server, where the server was located, which in fact is a secondary server being located in Fort Myers, Florida.
Yes, Mr. Gallup, to the point of the appeal, I was on that first panel. As I recall the opinion that came out, it said the trial court is directed to dismiss without prejudice. And in both briefs, nobody picks up on that, and I'm wondering if that's significant, and if it is, where do we go with it?
Right. Actually, Your Honor, the order was silent as to whether the complaint was to be dismissed with or without prejudice. It simply said, it directed the trial court.
The opinion says it's without prejudice under the conclusion section. And I agree with Judge LaRose. I was perplexed as to why neither side brought that up, and whether that gives us any guidance in the handling of your appeal.
Well, I don't think it is significant in the sense that certainly if it had been dismissed with prejudice, then we would have candidly taken appeal to the Supreme Court, because we would have argued, as we are arguing here today.
The point is, you're arguing that the trial court did not follow our mandate. Well, the trial court dismissed the complaint, period. Our mandate said dismiss the complaint without prejudice. So I have a trial court that did not follow our mandate, and I'm curious to know, with attention to the without prejudice language, where are we?
Well,
I mean, maybe it's...
I think in either event, even if the court had entered an order dismissing without prejudice, the critical issue, of course, that's before us today is whether we had leave to amend as a matter of right under Rule 1.190A. We assert...
Why do you want to argue that when there's an opinion that says dismiss without prejudice? And I don't understand the other side not addressing it either. I mean, see, before you duck the softball that's being thrown your way, you might want to make some argument that without prejudice means without prejudice.
If that might help you.
I agree, and I think...
Do you believe it helps your case?
It does, but I think both sides concede that the order was to be without prejudice. In fact, this Telesur tries to argue, well, that means you could have brought the claim in some other jurisdiction or refiled in some other. And candidly, our argument is, and I think it's the proper way to look at it, we could have and did amend, whether we amended as a matter of right under 1.190 or sought leave of court. Either way, we should have been given...
Did you argue to the trial court that our opinion said dismiss it without prejudice?
No, nobody argued that.
Why not?
That it was with prejudice?
Oh, no, that it was... Let me read to you the last sentence of the opinion. I'm not even going to read the whole last sentence. I'm just going to read the last clause. We reverse and remand for the circuit court to enter an order dismissing Senior's complaint without prejudice.
Right.
Did anybody tell the trial court that the opinion said it has to be dismissed without prejudice?
Yes, and both sides agreed it was dismissed without prejudice. Both sides, Telesur did not argue that it was somehow to be dismissed with prejudice. They simply argued, and the trial court, for some reason...
But their argument is without prejudice meant this case is gone, but it's without prejudice to filing a new lawsuit.
That's their argument.
But I'm reading between the lines on this brief, and from what I recall being on the first panel, there's a statute of limitations problem that's going to crop up.
Sure.
To file anew.
That's true, which is, of course, why they're arguing what they're arguing, and why we're arguing what we're arguing.
Yeah.
But the point is, what they interpreted this court's order to be, or opinion to be, was other than dismissing the complaint, the court somehow had no other authority to do anything else. That's what
I'm just totally amazed that I'm reading these briefs and nobody focuses on the language of our opinion as if it does not exist, and it just strikes me that that language means something. And I've got two briefs that don't say anything about it.
You know, thank you. I'm looking at the copy of our record of the order, and what I'm reading, it says, as the allegations in .SR's complaint combined with the language in the agreement are insufficient to support asserting personal jurisdiction over Telesur, we reverse and remand for the circuit court to enter an order dismissing .SR's complaint, period. Reversed and remanded with direction. So I'm not sure. I mean, that's what we were looking at.
So somehow in Westlaw, the case that appears in publication has the words without prejudice.
And we never looked at the Westlaw.
You're saying that the opinion you got doesn't say without prejudice.
May I approach? I mean, I can.
I believe you.
Okay.
I'm not sure how it's that way, but obviously counsel's given it to you. She believes it says it doesn't have the language. You believe it didn't have the language.
I appreciate
and
that.
And just so you know, I'm sitting here with a printout from Westlaw that says without prejudice. And we've all on the panel seen this one. So something is amiss.
I think you're right. It may have changed the quality of the argument. I think, though, but in fairness to Telesur as well, none of us interpreted even this order with the omission of without prejudice to mean that it was with prejudice. Even Telesur is not taking that position. And the question became for the trial court whether this order, and I think candidly, I'm not sure how it would have changed if without prejudice was in there. I think you're right. It would have bolstered my argument. But the point is, Telesur took the position, in the absence of that language or what have you, that the court had nothing further that it could do except to dismiss the complaint as instructed here.
Well, I'm sure we'll hear from Telesur's counsel, but I guess the argument is going to be with or without that language, your client was free to go back and file anew.
That's their argument. That was the only option available to them. And there's nothing in the order that says that, of course. And then the question to me is either we do what we did, which is to amend the complaint as a matter of right before the dismissal is entered, or if the if the dismissal had been entered by the trial court, we of course would have sought leave to amend, which under the same rule is granted, freely, unless there's reasons not to. And on the face of the opinion that this court entered, I think it's replete with examples showing that it's a pleading deficiency. It's not, for example, a statute of limitations issue where it says right on the complaint it's 2009 and we're in 2016 and that type of thing, and there's nothing you could do to plead around that. There would be a futility. Frankly, even then, as we argued in our brief, I think under 1.190 you still have the right to try to plead around that at least one time. But
remind me of the timing. When was the amended complaint filed?
The amended complaint
in relation to the order on appeal.
The amended complaint was filed January 9, 2013, and the order on appeal was after hearing.
As in April, I think?
Yeah, exactly. It was in April 2013.
So the amended complaint's not filed until after the order that purports to comply with our mandate?
No, the amended complaint's filed before.
Okay, I'm sorry.
After this court's opinion, and then we filed the amended complaint.
Right.
Telesur filed a motion to essentially dismiss or strike that as a nullity.
Okay.
And then we had a hearing on Telesur's motion before Judge Fuller, at which time, and Judge Fuller had held off until that date of the hearing on entering any order one way or the other. And at that hearing, he granted their motion, and therefore he entered the order dismissing the complaint and indicated that he felt constrained not to do anything other than the specific language
Okay.
of
Thank
the
you.
order. And of course, our argument was that the mandate was not a dismissal of the action. It certainly wasn't dismissal with prejudice of the complaint, and we should have the right to amend. And we did, if you did look at the amended complaint, just to make sure that we're not all sort of just wasting our time in a futile exercise, we believe we have absolutely put forward sufficient allegations as to Florida jurisdiction, alleging that the server is in Fort Myers, Florida, alleging that defamatory comments were stated to people in the state of Florida, alleging that the tortious interference occurred as to a business relationship that was to be consummated in the state of Florida. So it's not just an academic procedural discussion. We believe we have the right to have that amended complaint tested for its sufficiency at the trial court level on what may be, I assume, another forthcoming motion to dismiss or not.
Just a procedural question,
Yes, sir.
because I'm still puzzled by this without prejudice language not being in your opinion. Did either party file a motion for rehearing in the first appeal?
No, sir. And from our perspective, we interpreted the order clearly. We thought that it was being dismissed without, even though the language didn't say without prejudice, that it was without prejudice. It wasn't a dismissal of the action. And we understood under Rule .190.
Well, apparently the argument now has more weight because West is saying that it's without prejudice. So we'll have to figure out internally what happened.
I would love to know that as well, actually. And shame on us for not looking at the actual West published opinion.
Well, what you get in the mail is, from our perspective, that is this court's decision. So I don't know if internally that was an earlier version and the words were added to it before it was supposed to go out, or something else, but we will check into that on this end.
Someone at West wanted to give more clarity to this court's opinion. I don't know.
No, we'll find out what happened.
Okay.
Thank
Thank you for your time, Your Honor.
Thank you.
By the way, you didn't ask for rebuttal time. I assume you would like to.
I will reserve. Thank you.
Good morning. May it please the court. I'm Monte Sigmund of Kozak, Tropin, and Throckmorton on behalf of Appellee Telesur.
Well, you're both of you obviously are at a little bit of a disadvantage not seeing the version of the opinion that we're seeing. But to the extent that we believe we have language in the earlier opinion that says without prejudice, I'd like you to address that in your argument as well.
Sure, and I'll address that right up front. We don't think that makes a difference whether the opinion said without prejudice or whether it simply stopped and said dismiss the complaint. And the reason for that is because this is a personal jurisdiction challenge. It would not be appropriate to dismiss the entire action with prejudice because conceivably .SR can go somewhere else where it can establish personal jurisdiction over Telesur. And so to dismiss the complaint with prejudice, we think might prohibit it from doing that. And our position is not that we're seeking to prohibit it from filing its complaint against our client where it can establish personal jurisdiction. We just don't think it can establish personal jurisdiction here in the state of Florida.
But you would agree that there is at least potentially a statute of limitations problem?
I think that there may be a statute of limitations problem. I am not as familiar with the underlying facts as I came into the case a little bit late in the game. But I understand from my former colleague that there may be a statute of limitations problem here. But again, that is not something that my client, Telesur, is at fault for or controlled. I mean,
But ultimately, the issue of personal jurisdiction has never been reached on the merits. There was no evidentiary hearing. The trial court dismissed it based on a failure of pleading.
Actually, what happened here is that the process that the Supreme Court outlined in Venetian Salami happened. There was no evidentiary hearing, but the parties both sides submitted affidavits in this case, and that's part of the record on appeal in the prior appeal. So that was before the second DCA, the first time around. And we think that's an important part of our argument here, is that this is not simply a case of a failure of pleading, and I recognize that that's sort of the language that the second DCA used, but here we have evidence that was submitted to the trial court and to the second DCA. We've gone...
Wasn't the Venetian Salami application of the law and the cases that interpret it say that if the plaintiff does not allege sufficient jurisdictional facts, you never have the burden shift to the defendant to come up with an affidavit?
I think what Venetian Salami says is that the plaintiff can simply allege jurisdiction by the language of the statute without pleading the supporting facts. And then what the defendant does is the defendant comes in to contest the allegations.
If the plaintiff's complaint is sufficient. If the plaintiff's complaint alleges sufficient jurisdictional information, then the burden shifts to the defendant to challenge jurisdiction.
I think the plaintiff's complaint alleges the language of the statute.
Okay, well, again, unless there's something different about the opinion you received versus the one we have. The first paragraph of the opinion says, we reverse and remand because Dot failed to allege sufficient jurisdictional facts in its complaint
Right.
to establish personal jurisdiction.
Right. I don't think there's any dispute that that's what the
So
second...
your client really, I mean, I understand your client came in with an affidavit, but your client didn't have an obligation to come in with an affidavit. The trial court doesn't even get to the point of weighing affidavits if the initial complaint is deficient.
Actually, in the trial court's order, it makes reference to the, and I quote, competing affidavits. So I think the trial court considered the affidavits when it made its ruling and denied the motion to dismiss on the grounds of personal jurisdiction. I'm not sure whether the second DCA considered the affidavits.
They did not. The opinion says because we hold that the factual allegations in the complaint are not sufficient to show that jurisdiction is proper, we do not need to address the question of minimum contact. So they didn't, it didn't get past square one in the pleading stage. So that's the, so why shouldn't the appellant have a right to attempt to replead those facts at least one time?
Because here...
Since there's yet to be a determination on the merits.
Because we've gone through this process once. Telesur is a Surinamese company. At this point, it's gone through 2 appeals. We are, I think, 5 years into this litigation. And how many times do you go through the Venetian Salami process before it's enough, before a foreign defendant?
Had the trial court, in the first instance, before the appeal, the first appeal, had the trial court ruled, as our court did, that, look, Dot, your allegations aren't enough. You don't meet the requirements to allege personal jurisdiction, and so I'm going to grant the motion to dismiss. At that moment, wouldn't they have been entitled, as an absolute matter of right, to amend the complaint to try and fix the deficient allegations?
I think in the trial court, they probably would have had the right to amend
So what
one.
you have is a trial court making a legal error and saying there is enough for jurisdiction, you don't have to amend, everything is good, it's hunky-dory. Then it comes up on appeal, and we did what the trial court should have done, which is say, pleading of the complaint is deficient. So wouldn't that, because, I mean, it makes perfect sense to me that the plaintiff isn't going to amend the complaint in the first instance because they're being told it's okay. It's not until it comes up on appeal that they're being told, no, the trial judge got it wrong. In fact, your allegations aren't sufficient. And wouldn't that generally put everybody back at square one, which is if they can in good faith amend, they should have the opportunity to do so. And if they amend enough, or if they plead enough, then you file the affidavit, they file their competing affidavits. If they're not in harmony, then there's an evidentiary hearing. Let's say, assume your client wins on the merits. Case comes up on appeal, we affirm saying, okay, the evidentiary hearing, they don't get to amend again at that point. But I'm having trouble with the idea that their complaint was deficient, trial judge ruled incorrectly, and now under the current ruling and interpretation of our first case, the judge is saying you can't amend, God bless you, go start another lawsuit if you can.
We think this is a different situation than the cases relied upon by .SR for a couple of reasons. The first is because it's a personal jurisdiction challenge. All of those cases are different procedurally because they do not involve personal jurisdiction challenges. They are about, in general, failures to state a claim with a couple of exceptions, but none of them deal with personal jurisdiction challenges. And so we do think that this is a different situation. I want to draw your attention to the Boca-Berger case and footnote 2. In footnote 2, what the Supreme Court says is that it doesn't take a position about whether amendment as of right terminates once a complaint is dismissed. And so we think we fall outside of the Boca-Berger context because of that, because the Supreme Court didn't take a position on that. And we think that's precisely our factual circumstance here, because this court directed dismissal of the complaint. Under previous case law, that language means the action is done. And once the action is done, the right of amendment under Rule 1.190 terminates. I also would just like to direct the court's attention to the HomeAway Furniture case. That's a 2002 case from the 2nd District Court of Appeal. Very similar circumstances here. Defendants moved to dismiss for lack of personal jurisdiction. The parties submitted affidavits. The trial court denied defendants' motion to dismiss. Defendants took appeal. On appeal, this court only reached the first prong of the Phoenician salami analysis. It concluded that Florida's long-arm statute did not permit jurisdiction. And in that case, the court held on remand, the action against these defendants must be dismissed without prejudice to Mr. Horn's right to pursue these claims in another jurisdiction. That's at page 539. So we think procedurally that case is nearly identical to this one, and we don't
Was that case resolved as to jurisdiction on an evidentiary basis or a failure to plead basis?
I'm not sure that the opinion is perfectly clear. I don't think the opinion says that an evidentiary hearing was held, but it does say that the parties submitted affidavits. So my reading is that procedurally it's very similar to the case before the court today. And so I just wanted to direct...
In that case, you may not be able to fix the deficiency by additional pleading to bring you within the long-arm statute. So by necessity, you'd have to go someplace else. And I'm just wondering, in the first case that we had here, if it indeed is a pleading deficiency, perhaps additional facts could have been alleged, which would have then prompted the kind of evidentiary dueling affidavits that the trial court would have to resolve.
But Telesur's position on that is that the amended complaint that .SR attempted to file in this case does not at all satisfy personal jurisdiction requirements. And so if this court chooses to allow the amended complaint and to send this back down to the trial court, we're going to move to dismiss again. And that will be one of the arguments, is that even with the amendments, it doesn't satisfy personal jurisdiction requirements. And alternatively, we'll go through the affidavit process. Again, I don't know what more we'll have to provide for the court, but that process will restart again. And there's just nothing in the case law, nothing in Venetian salami that suggests that that's a process that keeps repeating itself, that that's a process that you need to go through more than once. If the court has any more questions, I would like to deal with them.
I think we're...
Okay. So respectfully, we ask that the court affirm the trial court's ruling in this case. Thank you.
counsel. Mr. Gallup, you have 3 minutes if you wish to
Thank you,
rebut.
Your Honors. I think the court has sussed out exactly, certainly what it intended in its first opinion to communicate, which is that this is essentially a bifurcated process. And what the trial court arguably should have done and didn't do was look at the pleadings first, and then if the pleadings were sufficient, then you look at the evidence or the affidavits and so forth. And admittedly, the trial court looked at both combined in the first instance, determined that we had shown sufficient pleadings and evidence to show personal jurisdiction and so forth. And then we came here, and this court very clearly didn't get to step 2 because it said step 1, the pleadings, the complaint was deficient, go back to the trial court and dismiss that complaint apparently without prejudice. And so, and to me, the case that is seminal here is the Wells Fargo case that we cited, which is, and this court has indicated that basically, once that happens, and we go back to the trial court, we are put in the same posture that we would have been in had the court done what this court indicated it should have done, which is apparently to dismiss the complaint without prejudice and with leave to amend if amendment was possible. And here, that's what we believe this court was intending to communicate. Unfortunately, the communication was not effectively communicated to the trial court. The trial court interpreted that they had no further jurisdiction other than to dismiss. There's nothing, of course, in Rule 1.190 that suggests that when a dismissal is without prejudice, you don't have the right to amend. In fact, you do pursuant to the rule. Certainly, there's nothing to suggest that your only remedy at that point is to find another jurisdiction to file a suit in, even when the pleading issue is one of jurisdiction. And again, Bokerberger and all of its progeny make that clear, that you should have the opportunity as a matter of pleading right at least one time to amend, and the proper procedure should be trial court considers the complaint first, whether the pleadings are sufficient. If the court finds that they are, then we get to step 2, essentially an evidentiary review, and that's where we need to be. And I thank the court. I ask that the court reverse the order dismissal and remand with instructions to allow amendment of the complaint.
Very good. Thank you, counsel.
Thank you.
Thanks, both of you. Next case is Sparks versus Kennedy.